Okay, so we're on here this morning, thanks to Donegal Local Development and Margaret there to talk about the Charities Amendment Bill 2022, which would be at the stage of going through further scrutiny with the Joint Committee on Social Protection. Um, Looking at it. So what you have is a bill as distinct from law, but the likelihood is, of course, that it will be law. So we're on here to sort of look at the sort of key changes to the Charities Act. So you're basically talking about the fact that there's a Charities Act 2009, which was updated on the 5th of September 2016. And so what you have now is a Charities Amendment Bill 2022, which looks at key changes to that Act. And this has implications, obviously, for charities up and down the country. Excuse me. So the way I've tried to summarize this is to sort of look at, and by the way, you will get copies of the slide presentation, of course, here, and it's quite wordy, so it will be helpful in that sense, you know, that you can look at it. So first of all, I'll talk about, you know, a lot of changes are just sort of little implication for yourself, in the sense that they're just technical changes, which we'll explain in terms of linking it with other laws that have come in since, and bringing it up to date and into speed with that. There is a new charitable purpose in it. The key thing is it strengthens the charity's legal abilities and legal powers. It brings a lot of what was in the governance code into, if you like, legal powers of the charity's regulator, and I explain how they do that. There's a lot of changes to the register of charitable organisations. You know, to get on the register, the upkeep, the keeping of information up to date with the register, that has become more onerous in this. Financial information reports are slightly changing. There's much more about offences and sanctions in this bill. It strengthens the regulator's hand in that. And also it has further things about connected persons. Connected persons meaning trustees who might be getting paid for something, or relatives or people related to trustees. And then there's a minor thing about other acts that have to change as well. So it's quite a comprehensive document, needless to say. So the first piece I'm going to sort of talk to you about is just sort of a broad sweep of if you like, general changes that haven't that much to do with you in the sense that terminology, for example. Now, one thing about terminology could be that, like, for example, you know, the word secretaries was used, you know, in the Charities Act, and they've just defined things like the fact that if you're performing the role of a secretary, but you're a member of staff, you're not a trustee. You know, you don't come under it unless you are a trustee. You know, so if you're an outside agent coming in, taking the minutes of meetings in the role of a secretary, you haven't got the obligations of what is a secretary if you're a trustee. You know, simple things like that. Cross references throughout the document. You know, there's so many changes. When you read it, there just looks to be so many changes, but it's simply, you know, that something said on page 3 has to be changed if you change something on page 89. You know, that type of thing. Cross references, indeed, coordination with other acts. So there's things to do with the revenue, for instance, the revenue commissioners. So there's certain changes here to do with tax and various things. So it means a change in you know, revenues. There's certain access to PPSN numbers. So that means changes in social welfare legislation and links into that. Changes to some of the acts to do with criminality, various things like that. So, you know, it has to coordinate and link in with other acts. Also, you know, Brexit, you know, previous terms are used about the EU. Now that has to be the EU plus the United Kingdom. The reason for that is that certain charities are operating in the United Kingdom operate here, and because the United Kingdom is now not the EU, technically it would have had to, if it has a charity that's operating in Donegal or in Ireland, it would have to set up new offices in the Republic of Ireland to actually qualify to be a charity. So they've amended the Act to let that not happen, so that life can continue as normal. And just other terminology. So there's reams of stuff in that I've actually cut out of this presentation in order just to sort of save you the sort of horror of going through those sort of changes. So the first substantive change is that it includes the advancement of human rights as a purpose. The purpose of charities, as you know, has to be to relieve poverty, to promote education. There are various things like that have been in it. So you see these purposes. To add it to that purpose is human rights. So that stands up for itself. It's just another purpose for that. So the next section I want to go to is strengthening the charity regulator's ability to use its powers within the Acts 2009. And I've put up there, first of all, a sort of a summary of the different things that do this. So I've put up a summary, first of all, and just to explain to you what that summary is. So for instance, previously, if something was going wrong, or so they detected something, they would have a number of things like they go straight to the Gardaí with something, because they're just restricted. It had to be, it was suspected criminality, so you would go to the Gardaí. Or you would go to the High Court. So if you look at that from a regulator's point of view, it means they're actually going outside their own organisation to remedy something. So in some cases, this didn't merit this act. So they now have the law switched around such that they can actually pursue this themselves initially. It doesn't mean that they're taking the law in their own hands in a bad way, but it means they can pursue it a bit further, say, we need you to come back with this, or if you don't, we'll sanction you, and we'll come to sanction later on. And of course, if those remedies don't work, they take you to court. But this time it won't be the High Court, it would be the District Court and the Circuit Court. So the District Court and the Circuit Court comes into play now. Plus a greater ability on their part to sanction charities. So the other thing, so in other words, they're able to apply more sanctions, and we'll actually come to what that means. What is a sanction and all that kind of stuff. Entering arrangement in public bodies. So previously, for instance, if they suspected something to do with your returns to the revenue commissioners, or for instance something to do with health and various things, they can now not just go to the regulators, which was in the old act, like say the Gardaí or the revenue. They can actually go to these bodies still, but they can also go to the HSE, go to any public body and request information. If you wouldn't mind muting just anyone who's just come in. So it means they can get more information, and they can also provide more information. So that's relevant in the case of the revenue, where they can share tax information, or social welfare, where they can get PPSN numbers and get access to PPSN numbers, and we'll come to that later. Also, the old Act had in it that you could only, this one here, that you could only it talked about a body, whereas now, it can apply to persons. So for instance, if a body was impersonating a charity, it would be open to sanction. Now if a person, or even a group of persons unincorporated, were impersonating a charity, they can be individually taken to court as well. So again, no longer needs to apply to High Court for immediate sanctions. It can actually apply them itself. and it can actually also go to the district court and the circuit court. And to do that, it has a memorandum of agreement with the Director of Corporate Enforcement when it comes to limited companies, for example. So previously there was a lot of exemptions for companies under the Companies Act 2014, and so therefore in terms of submission of accounts. So that is all stopped now, and if you're a company limited by guarantee and were a charity registered under the old system, then you're now coming fully under the charities regulator in terms of anything that applies to new charities. It will be the same as what applied to old charities. Just to explain that, new charities registered under Section 39 of the Act. Other charities came under Section 40 because they were already in existence before the Charities Regulator under a previous Act. So basically it's just a widening of the net of the authority, a greater ability to get information and to give information to other public bodies so that it can pursue or apply sanctions to charities directly and almost, as they say, summarily, in other words, immediately. And I'm going to just a little bit more detail on some of that. And when I've done that, I'm going to come back in the room for some discussion, and I'll flag up before I do that. So basically, what I've just said comes out in these different sections. These are the sections in the Act that have been amended, 39 to 46, or the particular ones mentioned. And I'm going to go through in a little bit more detail what these actually mean. So for instance, so the key changes to the register of charities. So the first thing that's a key change here is a change to the register. So the register, as you know, is something when you apply to be on the register of charities. And when you submit your annual accounts or annual report, you're adding to the register. So this particular, what I've done with the bill is I've taken headings like the register so that you can actually, focus your brain on one particular aspect at a time. And I'll explain more what these are. Trustee contact details are expanded, which means, for example, you may need to give them now your email address or your PPSN number. I'll come to the reasons for that. It talks about cut-off points in terms of if you have queries when you're registering. There's a cut-off point. In other words, there comes a time where they say, stop, no more, you're deregistered. So it's much more strict application of cut-off points when there's a toing and froing about registering a new charity. And I'll explain these in a little bit more detail. It asks for more details about your charity that's going to be published on the register. It basically moved from the governance code as being something, to inform you what to do, to penalty for failure. It adds that penalty for failure to comply. And also, when it notifies you or of things, it gives you a deadline to which to reply to things by. Appealing now, it restricted what you can appeal. There's a charities appeal tribunal. It restricts what can be appealed into there. As I said above, they can bypass the revenue commissioners now and deal directly with companies that had previously come under it. It can deregister charities without application to the courts in some cases. So it basically, you can see how it's strengthened. So I'm just going to take some of these things and give a little bit more detail on them. So first of all, looking at, and I've only extracted from the bill things that I think directly relate to you as a trustee. So you can see them there. A lot more information is being required. The reason for this is that the charity, if it rings the charity organisation at your local community centre and rings a staff member and it doesn't get through, or it feels it's not getting the information, it now has the ability, or will have the ability, to ring you as a trustee and contact you directly at your house and have a conversation with you. And in that conversation, it will be listening to see, do you actually know this charity inside out in terms of its governance? So that's not to put a fine point in it. That's it means it's a much more direct relationship between the charities regulator and individual trustees. So on the plus side, there are certain, under Section 39, paragraph 5, there are certain exemptions from providing the full suite of information. In other words, if you're a simple charity, things like that. So it simply broadens the circumstances under which that can be done. It gives itself more, more leverage or freedom in making exemptions. The charity's cut-off point. So, for instance, if you're applying to be on the register and there's queries have come back from the charities regulator, you have 21 days to reply. If you don't reply within the 21 days, you're deemed as not registered. And now the charities regulator can extend that 21 days in conversation with you, but it has the power to cut it off at 21 days. There is no appeal against that. So failure to supply required information deems the application withdrawn. So that's a more stricter interpretation of things. Currently, if you're an applicant, you can appeal to the Charities Appeal Tribunal if you're deemed ineligible as a charity or incomplete. In future, it will only be open to charities that have been refused status as distinct from charities where the process was deemed incomplete. So that's what I mean, that like if you're in that application process, the Charities Appeal Tribunal is cut out if you haven't. So that's a stronger gatekeeping in terms of allowing charities in. So this one, when I say CR, sometimes I'm meaning the charities regulator. I'm just using it for short. Sometimes I refer to the authority as they do, but sometimes I use the word CR, charities regulator. So you may already have uploaded your governing document. This strengthens the charities regulator's hand in allowing itself to publish governing documents. I think what it's looking to is a stage where every governing document of every charity is published on the internet. So to allow for greater degrees of transparency. And there's much more scrutiny now of the governing document. And if the governing document isn't up to scratch, it will be coming back and saying, we would like you to update your governing document. And failure to update the governing document would lead to deregistering you. So it can publish information of its own accord as well. You'll see that coming later when, for instance, if you have an infringement that you don't correct, it can actually publish that infringement on the register to let people know that you've infringed in a certain area. Even if they haven't deregistered you, they can say things, this charity has not fulfilled such a condition. And once even your application is being approved, they can ask you to do additional things after the application has been approved. And you'll see this section 73 of the Act, 73 and 74 do deal existingly about penalties. So what happens now is that those penalties were around things like criminality, around quite black and white issues. Now those penalties come in for failure to supply information to the charities regulator or providing inaccurate information. But we'll talk about more what these penalties are later. So notification requirements. I'll just let you read that there. So basically that's about 9b, that's about registration. So when you've registered and you've given information, then you have to notify the authority if you haven't done what you said you would do when you were registering. The obligation is on you to notify the authority. Again, it's a penalty if you don't notify the authority. And I'm conscious when you're listening to this that this sounds like a heavy stick, and there is no two ways of saying it. It is it is more onerous now in terms of the obligations of trustees, and there's no I won't spin it to you in any other way. So there is this. The heading on this slide here would really be notification. You would notify the authority if information ceases to be up to date or correct, or if you're winding up the charity. As I say, if information ceases to be correct, or if someone ceases to be a trustee. So the obligation is on you, but stricter obligation. And these things would have been referred to before, but what is being said now is if you don't do these notifications, there is a sanction, for that. So it really means being on top of it, really. So in the case of wind-up, a statement of the assets and liabilities of the acquisition and details of any proposed transfer of assets in the winding up. So that's a rare enough case, but I just included it because it is there. Just adding on here. I'll just let you read it, really, rather than listening to my voice all the time. So, again, it's really just saying that the charities regulator can specify how you give back that information to them. And of course, if you're amending the constitution without prior approval of the authority, this again is open to sanction. And there will be a more proactive looking at the governing documents or constitutions of organisations. So there's information in here about Section 40. Just to explain that, Section 40 again were those charities that were previously registered, and many of them limited companies. Up to now, the regulator would have to go to the revenue commissioners and get information. Under this new act now, it can go directly to the charity and get information. The reason they're very interested in that, as you see further down here, that some limited companies had certain tax entitlements prior to this, which would have been valid under the Companies Act 2014, for example. Now the charities regulator can actually look at that and maybe deem, it may be out of date or whatever. If they find that, they can question the charity and they must reply within 14 days. And if they don't reply within 14 days, they're deregistered. However, they can re-register and come under Section 39. But that's just to sort of show that. So previously, to deregister a charity, they would go to the High Court, but now it's more immediate. So they can make that without going to the courts. They can also, and this is new, they can also, if they look at a charity and realise it's no longer active, or as trustees are no longer competent to oversee the charity, they can then deregister the charity, and it can publish the list of deregistered charities. So again, what all this points to is in that the governance document always talked about this is the responsibility of trustees. What this is doing is it's putting that into law, basically. So in one sense, you're not seeing anything new in terms of the governance code, because the governance code talked about competency and skills, and you have all these good things in the governance code. What's happened, and in a way, charities were able to sort of carry out the governance code, submit the compliance response form, and all that. What this is doing is it's a sharper emphasis on the trustees themselves, their competency, and the regulators' ability to deal directly with trustees, and to make their own assessments of competency as well, and their own assessments of how things are happening. A bit like a school inspector, if you wanted to have an analogy, an education inspector from a school who would come in and examine if the exams have been carried out properly, rather than relying on the school to say it did. So, okay, I'll let you read that first of all. So basically, this is in the case of wrongdoing, of unlawful activity, and in that case, again, it's just a more direct route, consultation with the Gardaí. The Gardaí can now rely on law within the Charities Act to sort of do what it would need to do, So that's again just a sort of a legal thing, but it again means more immediacy of action. So again, appeals now can go through the Charities Appeals Tribunal. The good news with that is that it's cheaper, and it's more direct. It's of course, underneath the charity umbrella to a degree, rather than being out there as the High Court, but the High Court is extremely expensive and not really practical for most charities. And I'm going to finish this section soon. So again, this again is all about the register. If you think of this as it's all about the information on the register, or information about charities. So it used to be an offence for the body, a body to call it. It's now an offence for a person to say it's a charity or acting charitably, or to put it out there. But then if you are a charity, these are the sort of things it insists that you display. So again, I won't verbalize all that to you. There's just more stringent things on that. So I'm going to come back into the room for any questions that you may have, and you might want to just stop the recording at this point so that we can come in the room again. Okay, so I'm going to share a screen again and go to financial information. So again, so we've left the situation where we're talking about two things. We talked about kind of general cleanup to the legislation that's in the bill, and secondly, information on the register of charities and the regulations that have come in to make that more enforceable, if you like, in terms of the information that's put up there and when companies can be registered or deregistered. So now we're looking at financial information and reports and annual reports. So I'll give you a summary of the key changes first of all. So again, as I alluded to on the outset, companies under the Companies Act 2014 previously in certain cases had certain exemptions from reporting financial information. If they are registered as a charity, those are gone. It's up to the charity to if you like, remove those exemptions, and they have the same obligations as a normal charity. The charity regulator justifies that as saying it will be unfair for companies on the one hand, under certain conditions, to be exempt, and for charities doing the same thing that are to actually not have to provide the information. So they're using the argument of actually fairness. Plus, they're also using the argument that if a charity is providing a public service and its reputation is hugely important to the welfare of people, then it's so much more important for it to give more information to the regulator. That's another argument being used for the very higher threshold for reporting for charities than there are for companies. So it fixes thresholds, and we'll talk about that for reporting, auditing, and for annual accounts. It also improves the ability of the regulator to access information through trustees. It sets minimum numbers on trustees, and it codifies the duties of trustees. In other words, again, in the governance code, you would have been familiar with here are the duties of the trustee. What this now is, it places these duties, codifies them in the Act, meaning that they become law, and therefore subject to sanction if a trustee isn't abiding by these. And to Margaret's question earlier, again, if they're talking to the trustee, and they're having on the one hand, here are the duties of a trustee, and they're realising the trustee isn't actually operating to the codified duties, they have legal strength to deregister a charity or to take certain sanctions. I'll not say deregister it, but initially I'm sure they would not, but would take certain sanctions. So we'll go into that in a little bit more detail. So basically, this was the case that certain limited companies didn't have to submit proper books of account, and so therefore now, through a memorandum of understanding which will be in place with the Director of Corporate Enforcement, the charities regulator can ask that company to provide it with information. So charities with less than 250,000 will be permitted to meet their obligations. So that's up from 100,000. So if the income is less than 250,000, they can provide really what we're talking about, ordinary income and expenditure accounts. If the income is above €250,000, then you have to provide what is called SORP recommended practice. So which effectively means, and I won't go into SORP today, but what that effectively means, not just the accounts, but the purpose of your organisation, how you achieved your goals, how you achieve public benefit. It's like a set of charity statements that provides more soft information on what you're. So it's a more stringent set of accounting, and if you're above 250,000, that's what it looks for there. So again, talking about the annual statement of accounts, there's exemption from them if the following if two or more of the following conditions are met, and you see them there. So it's 10,000 really, but when they talk about a greater amount that may be prescribed, that means prescribed by the minister in certain situations. So it allows a bit of a change there. So as I say, it removes exemptions from companies, and so the Financial Reporting Council had set out legislation for how companies what type of accounting information that they should provide. So what basically this is saying is that the charities regulator can override that now and determine that these same companies provide more information if they are registered charities. In other words, it opens the way for the charities regulator to enforce SORP reporting. In other words, that more detailed reporting on the companies that are eligible for SORP reporting. In other words, turnover over 250,000. So as you can see, as I said in the outset, the charities regulator has become an adult, if you like. They're no longer the child. So they've gone to these other, if you like, legal institutions and these other pieces of legislation, and if you like, moved in with their own requirements and being able to change these legislations in order to sort of give it more powers. So this is about audit. So again, it's similar to the other cap exemption in terms of the exemption. So 2 or more of the following conditions being actually met. With you would have that exemption. It's quite low threshold, really. So here's the requirement to provide information. If a charity itself is refusing access to a premises, it can then obviously go to the individual charity trustees, and it will have the contact details. And obviously, if you don't, you're found guilty of an offence under Section 33, which we'll come to later, of that. So it's just making sure they can come and knock on your door. So basically, it's just another way of getting information and being able to publish information on the internet. So I see a hand up, perhaps, and maybe if we stop recording, we might just take a... So the next change that comes in is a new section under Section 54A, which provides for a minimum of 3 charity trustees, the majority of which should be in the EEA or the United Kingdom, and that also brings it in line with the revenue commissioners. So that's straightforward. So here again is the general duties of charity trustees. It's a new Section 54B in the Act. So it really, as I say there, it codifies in law the duties of a charity trustee. So in other words, previously a lawyer could say, well, look, it was guidance. That particular aspect was guidance. It wasn't really in the Act. So, you couldn't bring it into law. So basically it means that any breach of duty is sanctionable as misconduct or mismanagement. And it really is similar to what's in the Companies Act 2014, Section 228 as well. But it brings it into the charity agreement. So we'll just have a closer look at what does the duty of a trustee within the Act now mean. And so I thought I'd bring that detail in just to sort of explain that. So I'll just let you read it there. So if you're familiar with the code, there's nothing new in that. It's just bringing things into the Act more clearly. Again, if things have gone wrong and you've done something wrong, applying the remedy is equally a duty. And you see the slide in front of you. I'll just let you read it. So that talks about doing your duties applying a remedy. And the next section talks about members of a charitable organisation. So that came up earlier there. So again, greater emphasis now on the broader membership, and if you like, the register of members. So that slide will help you in terms of creating a register of members. And again, the Constitution would need to sort of mirror that. That would be checking, does the Constitution actually say what you're doing? So that would be that. So I'll move on from that, if that's okay. I'm conscious of time and stuff. So we're coming to the final parts of it. You will be pleased to hear. So just to go back, is really what we've done up to now is looked at the sort of general, if you like, housekeeping changes. Then we looked at the register and what needed to be on the register of information, and now what we're looking at is and then we came to the duties of trustees and their obligations and how that's now within the law of the Act, and now we're coming to what constitutes an offence, since we have been talking about offences and sanctions and such like. So we'll just, I went backwards there. So key changes here, it's an updating of legislation. So for instance, there's been a new Insolvency Act, so disqualification on the lines of insolvency had to be changed. So that's neither here nor there for you really, that's just like legal niceties. There are new grounds for disqualification for trusteeship and for notifying the charities regulator of ineligibility. That the regulator can hold a register of disqualified trustees. It brings in risk management into the law of it now. Again, you will be familiar with the governance code and risk management, but this brings it into law. And if there's been a report on a charity, a bit like you had, say for instance with with the HICWA coming into a premises, it's bringing the same to bear, the same strength, or the HSA coming in to a premises now, like the charities regulator, making it more enforceable what the inspector says. So essentially, I wouldn't dwell too much on that. They're just legal niceties. But here's the one to look at there. Trustees must be willing and able to engage in a fully transparent manner with the charities regulator when any issues or queries arise. That goes back to Margaret's question. It goes back to, like, they're in your face, basically. And out of that conversation can come a query from an inspector as to the competency of a board. So, there's always been the bankruptcy, criminality, those things to disqualify. Now you have to, notify the charity regulator of that. And then appeals can only be made into the charities regulator itself as a thing from the court process. And even court registrars, when there's a district court ruling, they need to inform the regulator as to that ruling, because that could be about disqualification of a trustee. So that's risk management. In another word, that's basically saying you really must have a risk management policy, or certainly at least a risk register in your organisation. That's now has a greater legal weight to it. So I won't delay on that because that's an obvious one there. Again, that just gives strength to the director. When a director comes out, or from an inspector's report, and a directive comes out from it, and really it's up to the charities regulator can actually specify what the remedy is and ask you to carry out that remedy. Obviously, if there's criminal proceedings, that takes it out of the charities regulator into the courts, and the courts apply the remedy, if you like. So all this relates to really is if there's a court proceedings, the charities regulator used to have to give them back, I think, within 3 weeks or 21 days or something. Now it can retain them as long as it needs them in terms of the court process, or during the court process. Thereafter it must hand them back. But it gives it more, 3 months, not 3 weeks, 3 months. It removes those inhibitions. So finally, sections 73, 74 and 77 of the original Act dealt with sanctions and orders and things. So it has introduced things called intermediate sanctions, which I will define coming up. It also introduces the fact that rather than either doing nothing or going to the High Court, to put it simply, it now has at its disposal a much greater range of flexibility and proportionality of approach if things go wrong. So that's the good side of it. They have the power to engage. They're not legally obliged to go to court straight away. They have certain remit within their own law. I'm not reading everything there, but it's self-evident. You've seen recent celebrated cases where people appointed by the charities regulator were themselves then fined for carrying out certain activities, or at least it appeared like that. So what is an intermediate sanction? That's what an intermediate sanction is. And those are the things that the regulator can apply of its own bat. And so this is a little bit detailed, but it says there, why would an intermediate sanction come in? And I specify immediately what those are, and I've laid them out there. Failed to provide information. It really goes back over the acts, and I summarised all of the dastardly acts that you could do that would be subject to an intermediate sanction. So it quite simply, if you misbehave in the first place, or if you fail to follow the inspector's direction, those are what lead to the intermediate sanctions. So, there's more play now in the district and circuit courts and facility provided for that now for the charities regulator. So this is the point that we talked about competency again. Where there is no wrongdoing per se, but there has been a breakdown in key relationships such that it cannot function. This will be determined by the courts with reference to company law on the grounds of just and equitable. So the charity regulator can refer something like that to the court if it believes that, okay, there's no wrongdoing, but things aren't happening here. There's something amiss. So that's just an alignment, but it talks about the determinations of the appeals tribunal. So finally, connected persons. So this is a bit more stringent, that hiring connected persons. A connected person is a trustee or a relative or someone with a relationship with a trustee. So it's just more controls on that. And I'll just go straight to the chase on that. So you need the charities regulator if someone is going to be engaged for services, provided that they're obviously providing services that are not services to do with being a trustee. They are ordinary other services. There's a more stringent application of that. And the new bill or the new law will actually spell this out in detail.
So Liam, can I ask a question?
Yeah, absolutely.
Just for clarity then, in a situation where, let's say, you've got a husband and wife operating in a charity, let's say the husband is looking after the financial side, and his wife is looking after secretarial duties.
So that's around connected persons and the controls to do with that. Basically a greater reliance on the charities regulator if there's any perception even of an inappropriate connection between a trustee and someone who's carrying out work for a charity. And obviously, again, it goes back to the information dimension of this. And it really talks there also about justification for having a connected person. There can be justifications. It's not that you shouldn't have a connected person. There can be a legitimate reason on the plus side for having somebody who's a relative or something working. And again, the charities regulator this time has the ability to discuss that with you. I won't dwell on this. It's just amendments to other acts. Odd things. I didn't know this until I read the bill, that charity can sell land to another charity that has the same purpose. Anyway, these are really odd things, some of them. So I'll just let you read that there. That's about the land. So the tax, there's a lot of changes to the Tax Consolidation Act, because obviously it's bringing companies limited by guarantee who were under the Companies Act and still are, but it brings some of that material under the remit of the charities regulator. And obviously getting personal details of and getting a PPSN number comes back to the Social Welfare Consolidation Act 2005. And so what's the overall implications for trustees? You know, you've seen all this now. What's the upshot of all that? It's really greater personal or individual responsibility. The governance code has always been there, not always, but it's been there for the last number of years. It's now more legally enforceable, rather than relying on the staff and the team in some cases to have the governance code up to scratch, the regulator is wanting to peer beyond that into the trustees' relationship with the code itself, and everything there comes onto the code. Really, there's nothing new in any of what you've seen this morning. It just has more legal weight to it. And that's the end of the presentation. We can now go back in the main room and maybe take any final questions or comments that we have.